We'll hear argument next in Case 11-697, Kirtsaeng versus John Wiley & Sons. Mr. Rosenkranz.
Thank you, Mr. Chief Justice, and may it please the Court. This case presents a stark choice between two plausible definitions of the phrase lawfully made under this title. Our definition is the more consistent with the English language and is the only definition that does not do mischief with the same use of that phrase each time it's repeated. Ours is the only one consistent with a 400-year common law history and 65-year-old right that was in the statute through 1976, and consistent with the principle that Congress doesn't abolish those things without being clear. Ours gives the copyright owners much of what they asked for when they were seeking an importation provision, just not everything, whereas Wiley's grants them rights far beyond anything that anyone could have imagined asking for back then.
But your reading is essentially once a copy is sold anywhere, the copyright owner loses control of distribution everywhere. That is essentially your.
That is correct, Your Honor. And to put a finer point on it, ours is that lawfully made under this title means made wherever in a way that satisfies U.S. copyright standards, made in accordance with.
And this notion of sold anywhere, end of distribution rights everywhere, that has been called, I think, the universal exhaustion principle.
International exhaustion, yes, Your Honor.
And we are told that no country has adopted that international exhaustion regime, that most countries adhere to the national exhaustion regime, which nobody is contesting here. That is, if it's manufactured in the United States and sold in the United States, that copy belongs to the person who purchased it, end of case. But if the exhaustion doctrine applies only nationally, then your argument is asking for something that runs against the regime that is accepted in most places.
Your Honor, I have a few answers to that. The first is it is not true that no country adopts national exhaustion. Congress adopted national exhaustion in Sections 905 and 906, 6 years after the statute was passed, as to microchips. But second, Wiley is making the point that there is now a norm. They say most states, most countries, that is. Back in 1976, Wiley is not even arguing that there was any international norm, much less that the drafters of the statute were focused on international norms. And the truth is that there isn't an international consensus around national exhaustion. We know that for a fact. In 1994, when 125 nations got together, they agreed to disagree on international copyright exhaustion principles, and they codified that disagreement to each his own in the TRIPS agreement.
Well, let's take, for example, the European Union, the position in those countries. Suppose we just transferred this case to one of those countries, the exact same case. And my understanding is that they would follow the national exhaustion.
No, Your Honor, not to quibble. They don't follow national exhaustion. They follow regional exhaustion. So
yes, but not exhaust. Sell a copy in Thailand, then it's home free all over the world.
Agreed, Your Honor, but it is regional. It's not national. And the point here is we've got to, of course, read what Congress wrote. What Congress wrote was lawfully made under this title, not lawfully made in the United States, or not lawfully made under this title and made in the United States. When Congress wants to say that, Congress says that very explicitly.
Do you mean by lawfully made under this title simply lawfully made in a manner that does not violate United States copyright law?
No, Your Honor. I would say lawfully made under this title means lawfully made in a manner that does not violate the standards.
Standards, okay. So it could be lawfully made in England, let's say, in a country that has compulsory licensing. It could be lawfully made there, but it would not be lawfully made under our copyright law.
Yes, Your Honor.
We don't have that.
Let me give an example that actually is consistent with what
So they at least they are correct in contending that what you're arguing for is not lawfully made lawfully made if the United States copyright law had applied where it was made. Is that what you're saying?
No, Your Honor. And the reason is that statute that you just described would do only a third of the job of the first sale doctrine. Everyone agrees the first sale doctrine applies at a minimum to products made in the United States. And if you use that counterfactual, if U.S. law had applied, it would indicate that that the first sale doctrine does not apply in situations where it was made in the United States. So the counterfactual
I don't follow that.
So the first sale doctrine applies to goods made in the United States and to goods made outside the United States, is our argument.
Right.
If it applies in the United States, if we're talking about goods made in the United States, the counterfactual, if this title had applied, would not work, because this title does apply to the goods made in the United States. And that's the core of the first sale doctrine.
So, Mr. Rosenkranz, is your theory of this statute essentially that this language means non-piratical copies as that's defined by U.S. copyright law?
Yes, Your Honor, if I may just change one word, because piratical is a mischievous word. Back in the day, when the 1976 statute was passed, piratical meant unlawful under the laws of other countries.
No,
yes.
I said as defined by U.S. copyright.
Absolutely. And the key.
So that's what the statute means. It's the statute, in your view, is setting up a distinction between piratical, pirated, whatever the term is, copies.
Counterfeit.
And other copies. And saying that distinction should be measured by U.S. copyright law.
That is right. And, Your Honor, the reason was, what was driving copyright owners crazy was this notion that there were lawless states out there that had no significant copyright protection, and we were applying their standards to products that were infiltrating the U.S. market. And one of the most important things to underscore here, which I think got lost in the Costco argument, is that the space that 602 does an enormous amount of work, even with 109, the first sale doctrine, carved out of it. Copyright owners wanted three things out of the 1976 Act with respect to importation, and they got 2.5 of them. The first was what we've just been talking about, Your Honor. It was driving them crazy that there were lawless states out there. They gave the example of Russia, where an agency approved the making and distribution within Russia of classic English language works. They got imported to the U.S., and they were competing with U.S. works, U.S. copies within our domestic market. And they got their wish to shut that down, to use U.S. law as the standard for those works. Secondly, they got coverage for copies that were lawfully made but stolen. And this was the one ask that the film industry had. We see it in the colloquies. They rented films abroad. The films, that was their business model. The films would get stolen, and the U.S. market would be awash with stolen films. And so they wanted to shut down with the importation provision those stolen goods coming into the U.S. market. And the third thing that they wanted is what's been dominating this debate. But it's only the third thing, and that was help dividing geographic markets so that they could go after the rogue distributors, yes, but also go after the downstream sales. They got half of that. They got a cause of action against the rogue distributors They did not get a cause of action that went downstream.
Mr. Rosenkranz, can I ask you it is a practical question, but I think it has a theoretical impact. A manufacturer can choose to contract, or a copyright holder choose to contract with someone here to manufacture their goods. They could contract with someone abroad, anywhere in the world, directly. They can choose to license their trademark and permit a distributor abroad to manufacture under their U.S. copyright, or they can permit a licensee to register the copyright abroad and distribute. In your definition of lawfully made under this title, does lawfully made under this title apply to all of those situations, i.e.,
Yes.
I think clearly to the manufacturer who manufactures abroad,
Yes.
clearly to the manufacturer who licensed a distributor to do it for it. But does it also apply to the copyright owner who basically gives the copyright to a foreign distributor and lets the foreign distributor register it abroad?
Yes, Your Honor. The only question under our definition is, was the making lawful, which is to say, was it authorized, whether it's by transfer of licensing or by transfer of copyright or in any other way? Is it lawful as measured by U.S. standards? And
That is broader than I thought. Then I'm not quite sure why you don't mean if this title applied. Because if the manufacturer who's manufacturing under the English copyright, because the distributor has an English copyright, is not manufacturing under the U.S. copyright, they're manufacturing under the English copyright.
Right. And, Your Honor, the reason that the language works the way we've described is because we are not focusing on whether the making was under this title. We're focusing on whether it was lawful under this title. Would this title, when you apply it to wherever it happens to be, whether in the United States or abroad, would this title say that this is authorized? Now, let me just circle back again. The reason, if this title had been applicable, doesn't work is because there are enormous numbers of situations, probably 3/4 of them that the first sale doctrine applies to, where this title does apply. And so trying to say where, if this title had applied would work for foreign goods coming in, but not for U.S. goods, which is the core of the
You don't have to say, you say both. Either it was manufactured directly and received an American copyright and satisfied all the conditions, or, if that wasn't the case, it was manufactured in a way that satisfied the conditions of the American statute, even though for technical reasons it didn't apply.
Yes, Your Honor. And in fact,
that's what your argument is, I take it.
In 2000,
we're off on a kind of curlicue here.
Yes, Your Honor. But so what Congress did was to find a much simpler, more efficient way to say all of that. In 2008, it figured that out and put.
I take it that the reason they changed the statute was just because they were worried about bailees or lessees or somebody under the old statutes not satisfying the first. They're worried about that. A printer lawfully obtains a book, and he shouldn't have advantage of the first sale doctrine. Well, he's in the middle of printing it.
So
and therefore you have to change the language. So they changed the language to lawfully made under this title. Am I right? Or if I'm wrong, why did they change it?
Your Honor, that is exactly right. And just not to diminish it.
Is it all right? Wasn't there also the question of allowing manufacturers to segment markets? So we'd have the copyright abroad governed by foreign law, copyright in the United States, governed by U.S. law. Wasn't segmentation of the market allowing people to do just what these people are doing?
So, Justice Ginsburg, my answer to Justice Breyer was about why the language in 109 was changed, that is, from obtained possession to lawfully made. And that, what Justice Breyer pointed out, was exactly why, because, and not to minimize Baileys was the movie industry problem. Baileys was stealing things from the manufacturer's loading docks or from shippers. But yes, Your Honor, there was also a segment of the publishing industry that wanted that third thing.
I couldn't find a word. I could not find a word of that in the legislative history. Erwin Karp, who was the strongest representative for the publishers, said you couldn't do that 10 years earlier. So is there — no, but you just said yes in answer to Justice Ginsburg's question. So she'll find exactly what there is there. So I would like to know what it is.
Your Honor, I was answering yes to, was this a motivation